Why is balancing IHL and human rights law in conflict difficult? Imagine trying to follow two sets of rules that sometimes seem to pull you in opposite directions. That's what it's like for legal systems during armed conflicts. When countries or groups are fighting, they have to follow international humanitarian law, which is all about limiting harm and protecting civilians. But at the same time, they are also supposed to respect human rights law, which guarantees fundamental rights at all times, even during war. International humanitarian law, also called the law of armed conflict, is designed specifically for war situations. It sets rules about what can and cannot be done during hostilities, like protecting civilians and prisoners of war. It recognizes that some military actions are necessary but limits their impact on human life and dignity. It is considered the special law for conflicts, meaning it takes priority over other laws when fighting occurs. On the other hand, human rights law applies all the time, whether there is peace or war. It guarantees rights like freedom of speech, the right to a fair trial, and protection from torture. But during conflicts, some rights can be temporarily limited or suspended, especially if there is a state of emergency. However, rights like the right to life and protection from torture are non-derogable, meaning they cannot be taken away even in war. Balancing these laws becomes tricky because they sometimes have conflicting rules. For example, international humanitarian law allows targeting military objectives, which might violate human rights law's protections for civilians. Also, human rights law's broad protections can clash with the more specific rules of international humanitarian law about conduct during war. Another challenge is figuring out when each law applies. International humanitarian law only kicks in during armed conflicts, but human rights law applies at all times. When conflicts are non-international or involve non-state armed groups, it gets even more complicated to decide which rules take precedence. Enforcement is also a problem. International humanitarian law relies on states and international organizations to enforce its rules, but it often lacks strong mechanisms for accountability. Human rights law has courts and treaty bodies that can hold violators accountable, but these are not always effective in conflict zones. This difference makes it harder to ensure laws are followed and civilians are protected. Legal conflicts can also happen because of the principle of lex specialis, which means the more specific law should govern. But applying this principle isn't always straightforward. Sometimes, it's unclear whether international humanitarian law or human rights law should take priority, leading to legal uncertainty. Modern conflicts add more layers of difficulty. Non-state actors, new technologies like cyber warfare, and autonomous weapons challenge traditional rules. These developments make it harder to interpret and apply both sets of laws consistently. Protecting civilians is the main goal of both laws, but they do so in different ways. International humanitarian law focuses on regulating conduct during war to reduce harm, while human rights law offers broad protections that are sometimes less tailored to conflict realities. Balancing these protections requires careful legal interpretation and practical decision-making. In the end, balancing international humanitarian law and human rights law during conflicts is a complex task. It involves understanding their different scopes, principles, and enforcement mechanisms. It also calls for ongoing efforts to clarify how they work together to keep civilians safe and uphold human dignity in times of war.